Hey guys, it's attorney Anthony Bandiero here, bringing you another Roadside Chat. And this question comes from an officer in Nevada. And actually, he's a corrections officer in the prison. And he brought up a great scenario. Do prisoners have a reasonable expectation of privacy in cell phones, right? So the scenario is an officer, in the prison found a cell phone, searched it without a warrant, and saw some information that helped prove that the prisoner knew, that he had it. I guess he's trying to say, oh, I have nothing to do with that cell phone. But, the evidence inside the phone shows that he made calls to people associated with him and so forth. All right. So normally the prison would get a search warrant. But the question for us today is, do you need one? And the answer is no, right? The answer is no. And the reason why is because the prisoner knows or should know that they cannot have that cell phone. Clearly, it's contraband, right? All the rules say it, no cell phones. They know or should know that that phone is absolutely prohibited in that facility. So therefore, when they brought it in somehow or obtained it, they're possessing contraband. And generally speaking, a person does not have any reasonable expectation of privacy in contraband. A good example of that is a Supreme Court case called Illinois versus Caballas, where the Supreme Court said that a dog sniff in and of itself is not a Fourth Amendment search if it is trained to detect contraband, right? So in that case, the canine was run around a vehicle during a traffic stop. It alerted to the presence of contraband, and a search ensued under probable cause. And Caballas lost that case because, again, the dog is not searching under the Fourth Amendment. Well, the same concept applies here. When officers in the prison facility search contraband, it's not a search because it doesn't implicate the Fourth Amendment. The Fourth Amendment prohibits unreasonable searches and seizures. This is not even a search, right? Because it doesn't implicate, it's not a protected item. Let me just give you an example from a case called United States versus Bash. I have the Westlaw citation. It's 2021 WL 3207252. So again, 2001 or 2021 WL, that stands for Westlaw, 320725. It's out of the Eastern District of California. It was decided actually very recently, July 29th, 2029. So here's a case where corrections officers searched a cell phone in a cell, and the Bash, the prisoner, is trying to complain about this search and saying that you guys needed a search warrant. And here's what the court said about that. It said, moreover, it is well settled that prisoners have no reasonable expectation of privacy in the belongings they keep with them. The Fourth Amendment prescription against unreasonable searches does not apply within the confines of the prison cell. California prisoners are prohibited from possessing a cell phone, and thus defendant Bash cannot claim to have had a reasonable expectation of privacy in the contents of the contraband cell phone, which he possessed in violation of the law. Well, I don't have the Nevada law in front of me, but I'm sure that either by regulation or directly by law, the prisoners in Nevada cannot have a cell phone. That would be considered contraband. Again, the law can basically tell the Department of Corrections for you to decide what's contraband and what's not, and the DOC would then lay out that cell phones are included. I also found another very persuasive case. This case is called, let me bring it up here. It's called United States versus Hart, and its Hart is UHART. Let me just kind of explain what's going on here. So the citation, by the way, is 735 F3D 972, a case out of the Seventh Circuit decided in 2013 against United States versus Hart, HUART, 735 F3D 972. What happened here is Hart was part of a a rehabilitation facility, right? And a halfway house. And so, but it was controlled by the Bureau of Prisons. He knew that everything that he brought in there was subject to search and so forth. So he's halfway, right? He's not necessarily full blown in a prison. He's 1 foot in the prison and 1 foot into society. But there was this rule, and he is being controlled by corrections officers. And the court said here is the defendant lacked, this is actually not what they said, this is a quote from Westlaw, how they digested the case. Defendant lacked a reasonable expectation of privacy in a cell phone or its contents while living at a halfway house. And thus the search that uncovered the phone and the images of child pornography stored on it did not implicate the Fourth Amendment. Halfway house was under the operational control of the Bureau of Prisons. House rules provided for the inventory of all items brought into the facility. Defendant was not permitted to possess a cell phone, such that any phone he brought into the facility was contraband subject to search and confiscation. And rules governing inmates who were allowed to have cell phones specified that they were subject to search at any time without reason. So Hart knew he wasn't supposed to have this phone because he was a child, predator, but he had it anyway. And it got searched by a staff member. They found approximately 214 images, most of them child porn. He's going down for that. Okay. There is no reasonable expectation of privacy. So in the end, do corrections officers need a search warrant? Not in my view. Is it valuable to get one for other reasons? Sure, there's all kinds of reasons why you'd want to get a search warrant. So, but at the end of the day, should the evidence be suppressed because you not get, a corrections officer does not get a search warrant? Absolutely not. Absolutely not. And by the way, even I'm just throwing this out there since we're having a nice conversation here. Even if there was a technical violation, which I don't think there is, but even if there was, that evidence can still be used in other non-criminal forums like parole hearings and so forth. So just one more little, you can use them in admin hearings and internal discipline for the prison. That actually doesn't have any very little Fourth Amendment protections anyway. So that's just another kind of sideline. All right, guys, I hope it helped. Keep your questions coming. Do me a favor. It doesn't take much to hit like, subscribe, and comment, share with your friends. All right. And I hope I've helped you get it right every time. See you next time.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.